not forgetting that the violence occurred at around lunch break at around 1:30. The voter turnout declined to 49 voters. This is clearly shown in the highlighted row in number 2 on table 3, which I have extracted and put in the judgment. The extract on row number 2 of the table 2 shows as follows. Record of voter turnout at the polling station. Details as per the PSD. Total registered voters were 641. Voters who had voted at 900 hours, 177. At 1000 hours, it should be 11 actually, because it goes by every 2 hours. It records every 2 hours. At 1100 hours, 287. At 1300 hours, 347. So between morning and 1300 hours, the voters were 347. From 1300 hours to 1700 hours, the total voters were 396, which shows that merely 49 people voted in the afternoon. The other witnesses to violence, was witness to violence was PW6, Dan Degwa Macharia, the agent for Safina Party at Gitiburi 2. He said that he traveled from Laikipia to participate as a party agent. He testified that after the fire started, the station was invaded by about 300 outsiders, some armed with sticks, accompanying CS Roko. He stated that the group entered the classroom and took things outside the classroom. He protested against CS Roko commandeering the station, but was handcuffed by police officers who were not uniformed. He was then beaten and detained in a police vehicle until 8 p.m. on that day. He said that he was personally beaten by CS Roko and was later sent away from the station, denying him a chance to witness the vote counting exercise. In cross-examination, he confirmed that the video did not show the ballot boxes being carried, that he saw ballot box aperture being sealed, that he later saw the ballot box being removed from the matatu vehicle by the presiding officer and his assistant, that he could not tell if seals were broken, and that the ballot boxes were taken to Stream 1. He did not report this incident to the police. Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu stations, or was systematic or pervasive within the electoral area or constituency. I'm talking about the evidence. I'm not talking about the allegations. It's the evidence. That is where the weakness of your case was. It's the evidence. The court relies entirely on what is brought into court. So if there are 500 other people, and I know the people of Embu may be feeling something about this, there may have been 500 other people who faced violence. It is possible. But unless the evidence comes into the courtroom and those people testify, proof is not there. The court goes by what is provided as evidence. I was where? Taking into account the evidence adduced concerning violence as a whole, the court is not able to find that such violence was widespread beyond Gitiburi and Kaungu. In fact, in Gitiburi, the only evidence that was provided of violence was Ndegwa, Dan Ndegwa, who said he was beaten by the CS. Then, of course, there was the incidents of the commotion and people with sticks, but that was not indicated as violence. I am not persuaded in the circumstances that the violence substantially affected the overall result of the elections. Despite this, though, there is no doubt that after the violence occurred at Kaungu, there was a decline in voter turnout from about 347 voters between 6 a.m. and 1 p.m. to 49 voters between 1 p.m. and 6 p.m. The voter turnout at Kaungu being 53.9%, compared, for example, to Gitiburi, where there was a turnout of 66.5%, and compared to Gitiburi 2, which had a turnout of 61.8%. This is compared to the average constituency voter turnout of 61.92%. So Kaungu achieved 53 instead of the average 61. If we do a calculation, theoretically, we can say Kaungu may be said to have suffered a turnout decrease of about 8%, 8% or 51 votes or voters, as against the constituency average. So on that issue, again, the petitioner fails. Issue number 6, whether there was bribery, treating and undue influence in violation of the Election Offences Act and the Constitution. PW1 stated that he received reports about serious cases of bribery at Kune, Kageri, Itira, and Kianamu polling stations. He also alleged that bribery was connected to the high numbers of assisted voters. However, he was not able to give any concrete direct evidence of bribery. PW2, the petitioner's chief agent, received reports of bribery at Riandu polling station and treating of voters with unga and cooking oil at Makunguru polling station. He highlighted a person called Nthiga Ndawa area who was allegedly involved in bribery, but he had no proof that the named person was acting on behalf of the fourth respondent. PW3 testified that she witnessed bribery at Kanyuambora polling station, but gave no further details. PW10, Anseta Wakere Maringa, and PW11, Lydia Mbuya Njeru, were the key witnesses for the petitioner on the issue of bribery. PW10 testified that on the occasion, on the election day, she was called by her former MP, Muriuki Njagagwa, who she knew. He asked her to go to the home of her neighbor, Edward Njage. And when she got there, she found many people and was informed that there were presents available for them. She saw those items in Edward Njage's home where Njagagwa was. They were then each given 2 kgs of maize flour, wheat flour, and rice, and Kenya shillings 500. The items were to be in exchange for her votes for the UDA government candidate in the by-election. When she refused to take the items and the money, she was told that she would not benefit, and Njagagwa left the items for them. Shown her affidavit, she said there was no indication that she took any bribe, though she alleged that she saw others taking bribes. In her oral testimony in cross-examination by Mr. Gashuba, PW10 stated as follows: Njagagwa was bribing people. He did it on behalf of Wamudende. He told us so. I did not see Wamudende. I took 2 kgs of rice, 2 kgs of ugali, 500 shillings, and unga ya chapati. I ate them. It was not written that they were for the election. I was hungry, so I ate. Others also got and they ate. Many who couldn't write also ate, and they were helped to vote. I have no affidavits of others involved. Lydia was with me at Edward's house. We were given the gifts together. Cross-examined by Mr. Kamotho, she reiterated, I think this is when Mr. Kamotho spoke the local lingua. You forgot you were in court. Cross-examined by Mr. Kamotho, she reiterated that she indeed took the gifts, that initially she declined, but eventually she took the things since they belonged to the government. PW11, that was, I think, Lydia Mbuya, testified that she was invited to Edward Njage's home where they were offered bribes in the form of food. They were offered the goodies so as to be assisted to vote for the fourth respondent, and that she agreed to vote for the fourth respondent. That is in paragraph 4 of her affidavit. They were told that if any of the invited recipients refused to vote for the fourth respondent, they would not benefit from the gifts. That most people took money and they were swayed to pose as voters needing assistance. In her oral testimony, she said that she was given 2 kgs of sugar, 2 kgs unga, 2 kgs ungangano, and 500 shillings by Njagagwa, who told them to vote for the fourth respondent. Further, PW11 testified that there were 2 ladies and 1 man who were given Kenya shillings 15,000 to find people who would vote for the fourth respondent, and that some of them would pose as assisted voters. She considered that she took the bribes and was influenced to vote as suggested. In cross-examination, she stated that she witnessed bribery outside the gate of the polling station, but she did not report the vice generally. She reasserted that she was bribed and the bribe was intended to influence her vote for the fourth respondent. In the present case, PW10 and PW11 have admitted repeatedly that they took the bribes intended to influence them to vote for the government candidate, namely the fourth respondent. I listened carefully to their evidence, in which they corroborated one another. They did not strike me as incredible, lying, or flippant. I believe their testimony as to the fact that they took bribes. I do not doubt that they were at Njage's house, where they said they were when Gachagua offered them the bribes. The submission by the petitioner was that the bribery was not only intended to influence the voters to vote for the government candidate, but also enable them pose as illiterate voters needing assistance. However, neither PW10 nor PW11 alleged that they were actually assisted to vote, nor was a single witness brought to testify who was an assisted voter. On this, the IEBC submitted that whilst PW10 knew that she was committing an election offense by taking the bribe from Gachagua, she did not report the same. IEBC, I challenge anybody to ever report to you that they were bribed, or any briber to report to you that they gave a bribe. There was no witness availed by the respondents to controvert the evidence of PW10 and PW11, although Gachagua was named in the affidavits, as was Njage. The petitioner invited the court to find that the bribery, treating, and undue influence were offenses in violation of the Election Offences Act. However, this court's jurisdiction is to hear petitions under Article 105, which provides as follows. The High Court shall hear and determine any question whether A person has been validly elected as a member of parliament, or B, the seat of a member has become vacant. Clearly, the constitutional jurisdiction of the election court is limited to making a finding on validity of the election and vacancy of a seat. The court does not sit as a criminal court when conducting an election petition. Thus, the finding this court can make regarding bribery, treating, and undue influence is that prescribed under the Elections Act and no other. In that light, the provision of Section 87(1) of the Elections Act enables the election court to make a determination regarding an electoral malpractice of a criminal nature. The provision, that is Section 87(1), is in the following terms. An election court may, at the conclusion of the hearing of a petition, in addition to any other orders, make a determination on whether an electoral malpractice of a criminal nature may have occurred. This provision merely entitles this court to make a finding as to whether a malpractice of a criminal nature may have occurred, not that it did occur. Further, in an election petition, the election court has no jurisdiction to determine a criminal matter or whether an offense under the Election Offences Act was or has in fact been committed, since that is an issue squarely within the jurisdiction of a special magistrate's court. Such court must be specially constituted by the Chief Justice under Section 23(1) of the Election Offences Act, which provides as follows. The Chief Justice may, by notification in the Gazette, appoint as many special magistrates as may be necessary to hear and determine matters relating to offences under this Act. In light of the foregoing, this court as an election court can make a determination only on whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Elections Act, but not on whether the offense of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. Ultimately, however, the question I must answer on this issue is whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election. From the evidence above, I am unable to find that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. We are talking about two witnesses who said they were bribed. And I only accept their evidence because it was not controverted by the respondents. Issue number 6. Whether there was a broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling. The petitioner made claims of a wide range under this issue, alleging broken chain of custody and unlawful handling of election materials. However, he was not an eyewitness in any of these events, neither was his chief agent, that is PW2. The main evidence that emerged in respect of this issue was that concerning Gitiburi Primary School Polling Station 2, where there was a fire, and Kaungu Polling Station, where there was an invasion by unauthorized people. PW6 Dan Degwa, the party agent for Safina Party, stated that he was at Gitiburi 2 when a lamp fell and triggered a fire in the classroom that was set up as a polling station. He said that they rushed out and then he rushed back into the room to retrieve his phone, which was charging there, as he helped put out the fire. He stated that CS Roko came to the station with about 300 people in tow, and they occupied the classroom, were placed inside the Nissan van, which was left unguarded outside, and he believed that they could have been interfered with. He said that by that time he had been handcuffed on the instructions of CS Roko, and some agents had run away. In his affidavit, PW6 could not confirm what happened at the voting in the classroom, as he was seated at the back observing. In his oral evidence, he reconfirmed that it was about 5 p.m. when the fire broke out, as the PO was attempting to light the gas lamp, or a gas lamp. That bedlam then broke loose, and the crowd of people started coming into the polling station. A video named NNK23 Collection Gitiburi was shown. He said that the crowd comprised of about 300 people, and at the time the ballot boxes were still in the classroom where they were left when the fire broke out. He further stated that locals salvaged the ballot boxes and took them to the vehicle, that the PO and DPO were not in the vehicle when the ballot boxes were taken to it. IEBC officers were called to come and collect the boxes from the vehicle, and they complied and picked the boxes. On further cross-examination, PW6 stated that there were things taken outside the polling station classroom by strangers. He said that he did not see in the video the ballot boxes being carried out by locals to the vehicle. Upon viewing the aforesaid videos, the court noted that as follows: there indeed was a fire, that there was commotion at Gitiburi, that there was involvement of large crowds of people, some armed with sticks, that there was also a van into which some IEBC officials in IEBC reflective vests were seen attempting to enter. However, no ballot boxes were seen in the videos. Hence, the videos do not support the allegation of third parties handling, I'm talking about handling, the ballot boxes. In his affidavit, PW7, Simon Kariuki, a voter at Gitiburi, stated that shortly after the fire was controlled, CS Roko came to the station accompanied by people armed with sticks and rungus, and they took the ballot box to the vehicle whilst beating people. That CS Roko demanded that the ballot boxes be brought to one classroom and ordered that the ballots from both Gitiburi 1 and 2 polling stations be counted together. One of the ballot boxes emerged from amidst the crowd and was given to CS Roko, who gave it to IEBC officials. That CS Roko demanded that the voters, sorry, not the voters, but the votes, that the votes be counted and tallied. He did not witness reopening of the ballot boxes again, and he denied signing forms 35A. He stated that the counting took place in one polling station at Gitiburi. RW4 Jane Karim Induma was a presiding officer at Gitiburi 1. It was her evidence through her affidavit that after the polling ended at 5 p.m., she secured the room before counting started. She confirmed that CS Roko came to the station and caused commotion. She noted that there was a fire at Gitiburi 2, that she prepared the polling station as a counting room. She made no mention of Gitiburi 2 in her affidavit. In her oral evidence, RW4 testified that there was a fire at Gitiburi 2. It led to a commotion because there was a large crowd of people. She took the ballot box and took cover in a vehicle. That vote counting started at 7 p.m., that the votes for Gitiburi 2 were also counted at Gitiburi 1. In cross-examination, she stated that she did not see CS Roko and that he was not involved. She admitted that she hosted another polling station and that no one authorized her to do so. When shown a video of the fire incident at Gitiburi, RW4 confirmed the incident was as depicted in the video. She saw the PO of Gitiburi 2 in the video with people in the crowd holding sticks at the scene. By that time, she said she had secured the ballot box in the vehicle. She said no polling officer for Gitiburi 2 was in the vehicle, but the boxes for Gitiburi 2 were there. On re-examination, her evidence was that after getting to the vehicle with her ballot box and with the security officer, she realized that she had left some personal items in the polling station. She thus left the ballot box in the vehicle to get those items. That was the only time she left the ballot box unattended. RW3 Lydia Kamau was the PO for Gitiburi 2. In her affidavit, she stated that after closing the station, she closed the KIMS and sealed the aperture at 5 p.m. She then called for a short break before counting began. At around 5:30, her deputy, Felix Mwaniki, lit a gas lamp which burst into flames. She managed to secure the ballot boxes. She telephoned Siakago police station and reported the incident and was issued with an OB number such and such. She stated that CS Roko came to the station and that his arrival caused some commotion. RW3 further stated in her affidavit that during the brief incident of the gas lamp explosion, the election materials remained secure. Let me read that again. RW3 stated that when the fire broke out, she took the boxes to the vehicle hired by IEBC together with the security officers and agents. She said that she and her team transferred their materials to Gitiburi 1 to count ballots, and they found Station 1 already going ahead with counting. In further cross-examination by Mr. Ndegwa, she stated that the forms which were burnt were KIMS Forms 32A. From the DR scrutiny report of 17th April 2026, the DR noted that the PSD for Gitiburi 1 recorded the fire incident as follows. Incidents recorded on page 30 as an accidental fire in Station 2 at 17:30 hours. Fire was put out and calm restored. Security backup. In Gitiburi 2, the PSD indicated that the PO recorded gas cylinder exploded and some of the forms were burnt. We were able to secure the ballot papers, ballot boxes, KIMS, and some forms. It is clear from the totality of evidence adduced that in Gitiburi 1 and 2, polling had concluded by the time the disruption arose from the fire and the crowd that invaded the polling stations. That RW4 took cover from the crowd in the vehicle, and at that time the boxes from Gitiburi 2 were in the same van without any officer from the polling station. It was admitted by RW4 that at some point she also left the box for Gitiburi 1 in the van unattended when she left to get her bags which had been left inside the polling station. With regard to evidence on Kaungu, RW7, Paulino Nthiga Njeru, the PO, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. He then stopped the election process for 30 minutes. When he reopened, voting continued, but the voter turnout was lower than earlier. He recorded in the PSD that locals and some politicians disrupted the polling process when some windows for the polling station were broken. Voting was disrupted between 13:45 and 14:15 hours. And action taken was the aperture was sealed at 13:45. All election material and officials were put under tight security. Thus, for Kaungu, it was the actual polling that was interrupted at 1:45 p.m. and the polling station was closed for 30 minutes. However, there is no evidence that during this time the election materials were removed from the polling station or were outside the PO's control. In summary, the evidence on this issue, we are looking at the issue whether there was broken chain of custody and lawful handling of election materials and violation of procedure of close of polling. In summary, the evidence on this issue is as follows. 1, at Kaungu, despite the fact of disruption of polling, the election materials were not interfered with. 2, at Gitiburi 1, the disruption occurred after closure of the polling station at 1730 hours as recorded in the PSD. At Gitiburi 2, the disruption occurred after close of the polling station according to the PO. Number 4, at Gitiburi 1, the evidence is that the election materials were left unattended in the van according to the PO. 5, the evidence concerning the election materials at Gitiburi 2 is inconsistent, namely that they were handled by unauthorized persons and also that they were left unsecured or unattended in the van or that they were secured. It is not clear. The evidence is inconsistent. From the DR's supplementary report dated 22nd April 2026, the results in Gitiburi 1, as recorded in the PSD, Form 35, and KIMS were consistent, save for one ballot paper marked in favor of the fourth respondent with no corresponding counterfoil. For Gitiburi 2, the report shows that the KIMS kit showed that the last voter was verified at 16:55 hours, while the PSD indicated that the polling was closed at 1700 hours. There was one ballot cast in favor of the fourth respondent, but no corresponding counterfoil for it. The totality of the above evidence discloses that for Gitiburi 1 and 2, there was broken chain of custody, possible and lawful handling of voting material, but no violation of poll closing procedure. For Kaungu, there was no evidence of broken chain of custody, unlawful handling of or violation of poll closing procedure. Consequently, there is no basis for finding that the irregularity or non-compliance was substantial and that it affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread
and occurred during the polling, a positive case would have been made to conclude that the violence affected the overall quality of the election and had a significant effect on the result.
Issue number 7, whether there was use of state resources, state security and public office to influence voters which constituted abuse of power and improper influence in violation of Articles 10, 73, 75 and 81E of the Constitution under the Elections Act. The petitioner's complaint of the use of state resources, state security, and public office to influence voters was, from an evidential standpoint, entirely contained in allegations. I have carefully perused all the evidence that was adduced with a view to identify concrete evidence concerning the use of state resources, state security, and public office to influence voters. I have not found any. What I find in this case is that there is evidence that CS Roko, together with Embu Governor and other public officers, were mentioned by witnesses as intimately involved in the campaigns leading to election day. It is probable, but not proved, that these officers were using state vehicles or state resources for transportation during the election period. They may also have used state resources such as police personnel. There is clear evidence that enhanced police presence was noted by many witnesses. That is also clear from the videos played in court, where in some cases, vehicles with no number plates were seen. It is also likely that by virtue of the power, stature, and influence of their public offices, these officers could readily command attention of or influence voters. No evidence, however, has been adduced concerning actual abuse of office and improper influence by any particular state or public officer. It was incumbent upon the petitioner, in order to prove issue 7, to provide at least the following evidence. Names of the public officers, this they did, a number of them, their designations and offices held, and particulars and nature of the alleged abuses of such offices, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced, and accordingly, I am unable to find in his favor on this issue. Issue number 8. Whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. With regard to delay in counting votes, the only evidence presented related to Gitiburi 1 and 2 were the breakout of the fire affected the timely counting of votes. Regarding exclusion of agents, the only evidence was that of PW6, who alleged that he was handcuffed and detained in a police vehicle until 8 p.m., hence was denied a chance to witness counting of the votes. From the DR scrutiny reports, agents of the petitioner were present in the stations where scrutiny was ordered, and they signed Forms 35A. With regard to defective and falsified statutory forms and opaque counting and tallying, the allegations in the petition were that Forms 35 were overwritten, resulting in opacity of results. In respect of Kerie Polling Station 2, Nazario Mugo, who was the PO, did not testify on the inconsistencies between Forms 35A and 35B, showing a total number of votes obtained and cast as 225 and 223, respectively, a difference of 2 votes. I looked at the form carefully, the Forms 35. The tally on the right-hand side for each candidate is indicated as in a total. That figure is supposed to be translocated to the column on the left-hand side, and the 2 should tally. So the key figure that is of interest is the one on the right-hand side, not the translocated figure. In respect of Gitiburi 2, RW3 Lydia Kamau, the PO, did not testify on the inconsistencies between Forms 35 and 35A and 35B, which indicated that the number of valid votes obtained and cast is 261 and 262, respectively. However, during scrutiny, the votes were recounted, and the number of valid votes cast remained 262, meaning that Forms 35B was erroneous by 1 vote. In respect of Mushonoke 2, Timothy Nyaga Maringa, the PO, did not testify on inconsistencies between Forms 35A and 35B, showing 304 and 303 votes respectively on the number of valid votes obtained and cast. Scrutiny was not done for this station, and the inconsistency of 1 vote remains unexplained. At Kamugo Polling Station 2, Form 35A indicates the number of valid votes obtained as 449, which is where the tally for each candidate is indicated. Whereas in the section of polling station counts, at item 5, the total number of valid votes cast is indicated as 456. This is on the left side of the form, 35. And the total rejected votes are indicated as 7. Shadrach and Nyaga and Jagib, the PO at this polling station, did not testify, and no further explanations were made regarding this inconsistency of 449 and 456 votes. On this latter inconsistency, it appears likely to the court that the 7 votes difference is attributable to the total rejected votes being carried to item 5 and added to the votes obtained. These unexplained inconsistencies in these votes, all these Forms 35 that I've referred to, these unexplained inconsistencies, I should say, add up to 10 votes in Forms 35. Add up to 10 votes in Forms 35A, a difference of 10 votes in Forms 35A and 35B, so that the election result has a 10-vote difference, unknown as to whom those votes would benefit. The scrutiny did not find anything to suggest any irregularity, but rather careless mistake in translocation from the vote tally column of Form 35. 35A, Form 35A. Regarding allegations that some 37 Forms 35A were overwritten and not countersigned, the court allowed scrutiny of only 8 of them where such overwriting demanded scrutiny. The DR's scrutiny report, dated 17th